All right, we are now beginning. Welcome everybody to the First District Court of Appeals. We have one case to be argued by Zoom this morning. We have Ms. Baumann here on behalf of appellant. Ms. Sullivan is here on behalf of appellee. Ms. Baumann, you will have 15 minutes to argue. Would you like to reserve any of that time for rebuttal? And I neglected to mention the case. I'm sorry. It's Chamberlain versus the Ohio Department of Job and Family Services.
Yes, and thank you, Your Honor. I would like to reserve 3 minutes, please.
All right, I will keep your time for you, and whenever you're ready, you may begin.
Thank you. Good morning, Your Honors. May it please the court. My name is Amy Bachman, and I represent appellant Jared Chamberlain, Special Administrator of the estate of Gary Bozeman. This appeal is before the court this morning because Gary Bozeman was issued an arbitrary denial without cited authority in clear violation of OAC 5101:6-2-03. The primary issue before Your Honors this morning is whether the lower court erred when it determined that the administrative decision upholding that denial was proper and agreed with ODJFS, finding that an email sent only to Mr. Bozeman's authorized representative was sufficient to deny him a change in coverage request. Mr. Chamberlain maintains that the unpaid past medical request was properly made, is not precluded by anything in the OAC, and that the denial of said request was improper because no proper notice citing to supportive section of the OAC was sent, nor was any notice sent to Mr. Bozeman himself as required by OAC 5101:6-2-03 subsection A.
Ms. Bachman, let me interrupt and ask you a question.
Sure.
If his authorized representative got the notice and if counsel was present and fully represented him at the hearing, what prejudice, if any, did he suffer by the notice not going directly to him, but rather to the agent?
Well, it's an overarching due process argument, Your Honor. The issue is, yes, in this instance, Mr. Bozeman did have counsel. It was me. I've been with this case since it was at the state hearing stage. The problem is that the OAC requires that the notice go directly to the resident or the recipient in addition to the authorized representative, as well as to the authorized representative. And in this instance, yes, Mr. Bozeman did have counsel, but the problem is that the OAC section that governs these notices is pretty clear about the things that they're supposed to include. And the things that they're supposed to include are a clear and understandable statement of the action taken and the reasons for it, applicable regulations, the right to and method of obtaining a state hearing, and a telephone number to call about free legal services. And in this instance, yes, Mr. Bozeman did have counsel and he had an authorized representative, but we have to look back at the purpose of Medicaid. The Medicaid is to cover benefits for individuals who have low income, and that often includes the elderly and disabled, just by nature of what Medicaid is. And the issue is that the Medicaid guidelines are in place to safeguard those who fall into these categories. Not everyone's going to know that they have the right to free legal counsel. Not everyone is going to understand what the regulations supply that they're supposed to have. They aren't going to understand the reasons that they were denied. And so the fact that due process was not properly carried out here is the issue. And now we're at this level of the court where, you know, the decision that Your Honor's issue is going to probably be looked at and reviewed by other higher courts here in Ohio. And it makes it difficult for those who don't have legal counsel or who don't have, you know, the know-how to navigate the Medicaid system.
But wouldn't that be a different case? I mean, if we were presented a case where the proceedings went on without somebody being represented by counsel, without knowledge that the hearing was even happening, that would be different than what we have here.
You're correct, Your Honor, it would. But because the regulations are so clear about what is required, and that was not followed here, and in fact, it was testified to under oath. The caseworker testified under oath at the state hearing, one, that not only did she not issue any notice at all, when normally she did issue a notice, she just sent an email. But number two, she didn't cite to an applicable code section because one didn't exist. And so, you know, that goes back to the second point of the argument. And
can I interrupt you before you get to your second point?
Sure.
Okay. Following up on Judge Meyer's question, though, let's say that, just for the sake of argument, if we were to, on the merits, decide against you and
Mhm.
decide that that the arrears were not covered
Mhm.
under the patient liability, what would you have us do on remand? I mean, would the notice in and of itself be a reason to reverse?
Yes. Yes, that's part of our argument. Part of our argument is when it was, so the state hearing decision actually found that notice was not proper, but they didn't do anything to correct it. And on administrative appeal, the administrative appeal decision actually found that the whole notice argument was moot. And it's part of our position that the argument is not moot because the due process that's laid out in the OAC, and it's in, I think, primarily in the first assignment of error in my merit brief, it wasn't followed. It wasn't followed. And so here we have a person who happened to be represented by an authorized representative who engaged counsel, but you're not always going to have that. And so therefore you have to follow proper procedure. Part of the issue is proper procedure, and proper procedure wasn't followed. And not only was it not followed, as I said, it was testified under oath by the caseworker at the hearing that it wasn't followed.
At what point did you make a due process argument? Did you make that argument before the magistrate?
I believe so. Yes. I think actually I may have made it back at the administrative appeal level, and I would have to double check. I mean, I don't know that I fully went into an argument, but I did argue that it's part of the due process that you have to go through the proper steps as outlined in the OAC in order to properly deny someone and use that as the reasoning. This is something that, could have been corrected back at the state hearing stage had just a proper notice been issued with a code section, with appeal rights, with the language about how you get counsel, all of that.
But what difference would that have made in this specific case?
In this specific case, what difference would it have made? Well, again, it's following proper procedure. I mean, again, it goes back to the argument of who is Medicaid here for and what is it supposed to do? And not everybody is going to be in the position that Gary Bozeman is in. So if it happens to Gary Bozeman that procedural due process isn't followed appropriately, it could happen to somebody else who doesn't have coverage, or, legal coverage or legal representation, and they'll be denied improperly. The issue here is, what was the reason? What was the reason for denying? And because the caseworker testified that she didn't have a reason, that he didn't fall into any exception that is outlined in the OAC, there are enumerated exceptions for those who cannot recover a change in their benefits from unpaid past medical balance, or UPMB. Mr. Bozeman did not fall into any of those exceptions, and she couldn't point to where he would fall to preclude him. And so,
does that matter though? I mean, this caseworker isn't a judge, isn't a decision maker. I mean, does it matter why? I mean, does it matter that she testified that there wasn't a legal reason?
It does matter because, again, if you go back to the Ohio Administrative Code, and I can point to the section, it's OAC OAC 5101:6-2-03. It governs Medicaid notices, and it indicates that notice is, first of all, required when the agency denies an application for or requested change in public assistance for social services. And then it goes on to enumerate more guidance of what the content of a proper notice is supposed to include. And among those things, it must contain a clear and understandable statement of the action taken and the reasons for it, cite to applicable regulations, explain the individual's right to and method of obtaining a state hearing, and contain a telephone number to call about free legal services. And federal law actually has a companion regulation which covers the same requirements, essentially. Ms. Lanzalotta's email wasn't an actual notice. It was just an email back to the authorized representative, and it didn't contain any of that. It contained none of that information.
Ma'am, let me ask you then, at the state hearing, did you request a continuance in order to get Mr. Bozeman the proper notice that you believe that he was entitled to?
I did not request a continuance, Your Honor. We simply argued that the notice was improper and we requested, among other things, correction of that. And as I mentioned, the state hearing decision did actually find that there was no proper notice that was issued, but it agreed that it agreed with ODJFS that the denial could be upheld based upon the other part, which is the whether or not it fit into allowable exceptions for what the request was. So I don't know if that answered your question.
It did. It did.
No, I did not ask for a continuance at that time. But one thing, as I said, one thing that could have been done is a notice could have just been issued, and it never has been. It never was. So our argument is that the due process violation in that sense hasn't been cured because he's never been denied with a proper notice that comports with all of the things that are set out in OAC 5101:6-2-03. And that is required. It's not optional, it's a requirement. So in order for it to not continue, it's our position that ODJFS needs to issue these proper notices. Again, going back to the discussion.
You have 2 minutes left if you'd like to reserve 3.
Okay, thank you. Thank you, Your Honor. Just going back to the issue of prejudice, I know it was brought up by the lower court. It was also brought up in ODJFS's brief, and I just wanted to address that briefly. The prejudice that Mr. Bozeman is alleging is actually threefold. First, it's the denial without issuing the proper notice, which followed the proper regulatory requirements by federal and state and allowed for that proper due process to happen. Second, it's his position that there's no just cause that could be given for failure to issue the proper notice or the failure to correct the notice issue. No one's still been able to testify to why that happened. And third, because there's nothing which specifically excludes Mr. Bozeman's request as outlined in the OAC, and this is outlined in my third assignment of error in my brief, it must therefore be presumed as an allowable expense. Mr. Bozeman, Mr. Chamberlain, for Mr. Bozeman, understands that there is agency deference for the statutory construction, but the issue here is unless specifically excluded, there are exclusions that are specifically accounted for within the OAC, and Mr. Bozeman doesn't fall under any of those. And so without falling under one of those exclusions, it's impossible to deny him unless an exclusion is hit. The intent of putting this together was to be very clear about who falls where. And because there's nothing that cites to this, it makes it almost an impossibility by Mr. Chamberlain's position to deny. So that's our position at this point.
All right, and you have 4 minutes left if you would like to reserve all 4.
I would, thank you.
All right. Ms. Sullivan, you'll have 15 minutes.
Good morning, Your Honors. May it please the court, Angela Sullivan on behalf of the Ohio Department of Job and Family Services. The lower court's decision affirming the administrative appeal decision should be affirmed. First, any error in complying with notice requirements was not prejudicial because appellant appeared at the state hearing represented by counsel who did not claim confusion about what the issue was and what the and what was going to be discussed at the state hearing. In fact, at the state hearing, in the transcript, which is before this court, counsel did argue that the notice was deficient, but didn't argue any prejudice at that time, and didn't until the court. Second, the federal regulation does not apply because this is not an action as defined by the federal regulations. Third, the administrative appeal decision did not conclude that the notice issue was moot. So that assignment of error should be rejected. And finally, as to the merits of this case, the regulation, the rule in question, 5161-607 F6 is a question of law. So this court can review this question of law as to whether or not the agency, whether or not agrees with the agency's interpretation and its decision that Mr. Bozeman's application of the law would lead to an absurd result. So turning first to the question of the lack of notice. Yes, the court did hold that the notice was deficient. However, it held that it was not a violation because there could be no prejudice shown. And to have a reversal, you must show both error and prejudice. And I would further note that the administrative code specifically says in 5101 6-801 I3 that in order that administrative appeal decision should affirm a state hearing unless they can show that there was an error affecting the outcome of the appeal. And here it was a question of law. So, and Mr. Bozeman was represented by counsel. So, the question of law could be decided regardless. And I would say that this concern that there could be prejudice to other parties and other cases, as Your Honor said, that's not before this court. And before this court, there's no showing of prejudice. And there can't be made, arguments about possible prejudice for other people in other cases.
Can I interrupt and just ask you
Yes,
a practical question that's been on my mind? Since he only received, since the amount he received monthly was reduced and he was receiving a lesser amount, was there a way for him to alter the payment that he was required to make?
The agency does an annual recalculation of the recipient's patient liability. And it depends on their income. That's why his increased, that Mr. Bozeman's increased every year because his income increased. I will note that he did make an argument in federal court that the agency miscalculated his patient liability and that it should have reduced it by the tax lien. And the federal court rejected his argument in the case of CareSpring versus Dungy in 2018. So he did attempt to do that, and it was rejected. So does that answer your question?
Yes, thank you.
Thank you.
Let me ask you, Ms. Sullivan, what about the argument that since there's no section of the administrative code prohibiting what Mr. Bozeman would like to see happen, since there's no section, what's your response to that? I mean, the argument is there's no section disallowing, therefore it's allowed.
I would argue the opposite and say because the court properly held that because there's nothing that permits the agency to treat patient liability, unpaid patient liability as an unpaid medical expense, that the agency is not permitted to do it. And the ODJFS and ODM and the local county agency, which made the decision in the first place, they're creatures of statute, and they have no more authority than what's specifically conferred. So, if a statute or rule in this case is silent, then they would lack authority to take an action. And that I pointed out to the Wood versus Simmers 10th District case, which, while of course is not binding on this court, is certainly, in my opinion, persuasive. That an agency must be, the authority for them to act must be clear or clearly implied. And in this case, I would argue it's not. And the reason why it is not plainly placed in the regulation to allow a patient's liability to be offset is because it would lead to an absurd result. The intent of this rule, of this patient liability, is to allow someone who has higher income than would otherwise, be permitted to qualify for long-term care. It's specific to long-term care because we all know how expensive long-term care is for anyone, not just the very, very poor or disabled. So the intent is to allow some people that have a higher income to qualify for this long-term care that they they otherwise wouldn't qualify for. However, they have to pay towards their own care. They have to pay a certain amount. And it's, like I said, it's recalculated once a year, but it can be done more often if there is a change in income. He's basically seeking Medicaid to pay more so that he can use some of that freed up income to pay a tax lien, or it was paid off within a couple of years. So for this 2-year period, that was his argument. And that would encourage every patient who has patient liability, so patients with higher incomes, to just refuse to pay until the arrears piles up, and then say, oh, this is past medical expenses, so I'm going to offset it. And that would completely render this patient liability obligation meaningless. And it's not meaningless. It is a requirement, and it is required in order to help protect the solvency of Medicaid. It's not an unlimited amount of money. So people with more income need to pay some of their income towards their own care.
And back to my initial question.
Yes, Your Honor.
The argument and the position is his income was not reduced. His liabilities may have gone up, but the fact that he owed this tax lien didn't reduce his income. It just meant that less of his income might have been available for certain things.
That is my understanding, yes. And there are exceptions. There are reductions made to the patient liability. For example, they have some small amount for personal use, like haircuts and things like that. So there is a list in the rule of everything that's exempted from your income.
And tax liability isn't one of them.
That was not one of them, because in effect, it would mean that the taxpayers are paying off your tax lien, because they'd be paying more for Medicaid. So I assume that's why it's not an exception, because the taxpayers shouldn't be paying your taxes. But it was a 2-year period. I apologize if you can hear that. There's a truck outside. I apologize if you can hear that noise. But that, again, the need to read the statute, read the rule to have a meaningful patient liability is the reason for ODJFS's decision. And that is the reason for its application of the rule. Unless there are any additional questions, we would ask this court to affirm the lower court's order as it was supported by reliable, probative, and substantial evidence and is in accordance with law.
Thank you, Ms.
Thank
Silverman.
you.
Any further questions from the panel? Ms. Bachman, you have 4 minutes remaining.
Thank you, Your Honor. Just to briefly address the issue of the tax lien from Mr. Bozeman's standpoint, paying that tax lien was not optional. His only source of income while he was living was Social Security. That was subtracted from his Social Security payment each month before it ever hit his account. So it was taken before it was deposited. He never had it available to him. Other exclusions that apply under that, just for Your Honor's information, include things like child support or an alimony payment, other payments ordered by the court. So yes, there is, to your statement, that there's some income that's actually not available for these types of things. This would fall under that instance. Every dollar that he got that remained from Social Security, with the exception of whatever those small amounts were that he was allowed for personal expenses each month, went directly to pay his patient liability, every single dollar. So, but that's not actually at issue here. I just wanted to clarify that for the court. I just also wanted to briefly address the issue of what's allowable as medical expenses under OAC 5160 :1-6-07 subsection F6B. And again, you know, that section very clearly sets forth what is allowable as a past medical. It says cost for institutionalized individuals incurred expenses for medical care recognized under Ohio law, but not covered by Medicaid and not subject to third-party payment. Third party assuming insurance or something like that. Other health insurance. The unpaid past medical expenses are required to meet 3 criteria under that regulation, though. The service must have been medically necessary as determined by the administrative agency. Expenses for the medical care must not have been incurred during a restricted Medicaid coverage period, and the request for the UPMB can only be initiated by either the individual themselves or the person or entity who has legal authority, including the authorized representative. And Mr. Bozeman, you know, Mr. Chamberlain argues that Mr. Bozeman fit into this section. He had been approved for Medicaid. He had been on Medicaid since he was in the facility. Level of care had been provided, so he was medically necessary recipient. The expenses that were incurred at Indian Spring were medical related, and there was no restricted period that was in place during the time period in question. Further, Indian Spring requested it and they were the authorized representative. So these are the only guidelines in the entire OAC that I could find that set forth how to handle a UPMB request. And under each one.
So it says the cost of the institutionalized individuals incurred expense for medical care not covered by Medicaid. I mean, in general, weren't these costs covered by Medicaid?
Well, part of them were, but not all of them were if he had a remaining amount that was left. And so that
in general, though, his care was covered by Medicaid.
He was a Medicaid recipient, yes. So his care was covered, but it's our position that this did not fall under that because there was a remaining amount that was left that was available. And he was not otherwise covered for that remaining amount. Without some type of regulatory support to show how he could have otherwise been excluded under this exception. And Ms. Lanzalotta at the state hearing testified that there wasn't any exception. We have a hard time finding how he could be precluded from doing this.
And Ms. Brockman, you are at your time. I'll let you finish that thought.
Okay, sure. The only thing I was going to finish with was just to ask that, we're requesting that the court here overturn the decision and remand it back down for a proper notice to be issued that comports with the appropriate guidelines set forth in the OAC.
Thank you. Thank you. Any further questions from the panel?
No.
All right, that will conclude our Zoom arguments in the First District Court of Appeals today. Thank you both very much for your arguments. We will give you a timely written opinion.